So everyone, hope everyone is in pink of their health. This side Suyash Tripathi. I'm a second year student pursuing BLLB honors from MIT Law School, Gwalior, Madhya Pradesh, and currently I'm working as a legal intern with LEXIS and Company. So today we are going to discuss a case law, that is Lalita Kumari versus Government of UP and others. The case number was Criminal Appeal number 1410 of 2011. The court was in the Supreme Court of India. Bench was P. Sathasivam, B. S. Chauhan, Ranjan Prakash Desai, Ranjan Gogoi, and S. A. Bobde. Decided on, so it was pronounced on November 12, 2013. Relevant statute was Section 154 of Code of Criminal Procedure 1973. The citation was AIR 2012 SC 1515. So brief facts and procedural history. The writ petition was filed under Article 32 of the Constitution by Lalita Kumari, who was a minor, through her father Sri Bhola Kumar, for the issuance of a writ of the habeas corpus as the officer in charge of the police station who did not take any action. The petitioner stated that even after registration of FIR, no concrete steps taken to recover the minor girl or trace the accused. The court on 14/7/2008 passed a comprehensive order expressing its grave anguish on non-registration of the FIR even in the case of cognizable offence. The matter was heard by the two judges bench in the same case in 2008. Thereafter, which the matter arose in 2012 by three judges bench, where the apex court referred the matter to the constitutional bench as there were extensively conflicting decisions. Issues raised in the case. The important issue which arose for the consideration in the referred matter is whether a police officer is bound to register a first information report upon receiving any information relating to commission of cognizable offence under Section 154 of the Code of Criminal Procedure 1973, or the police officer has power to conduct a preliminary inquiry in order to test the veracity of the information before registering the same. So here the case is related to the registration of FIR on receiving the information, or the police officer first has to conduct a preliminary inquiry before registering the FIR, or he should register it immediately. So petitioner contentions. The use of the word shall in the section 154(1) indicates that there is no discretion left to the police officer except to register the FIR. In support of the proposition, reliance was based on the following decision, which is B. Premnand versus Mohan Koikal, MS Hira Lal versus State of UP, and another. Section 154(1) mentions the word information without fixing the reasonable or credible, which indicates that genuineness or the credibility of the information is not a condition precedent for the registration of the case. Respondents' contention: State of West Bengal, Uttar Pradesh, Rajasthan, and Madhya Pradesh contended that the registration of FIR is mandatory was Section 154 of the CRPC if the information discloses a cognizable offence and no preliminary inquiry is allowed in such situations. States of the Chhattisgarh and Maharashtra contended that a preliminary inquiry should be conducted before the registration of FIR on the following basis. The provision of Section 154 Clause 1 must be read in the light of Article 14, 19, and 21, which provides that no citizen shall be subjected to malicious prosecution and an innocent shall not be implicated in a criminal case. So, in Section 154 Clause 3 enables the complainant to approach the superintendent of the police to register the FIR if the same is refuted by the officer in charge of the police station. This indicates that police officer is not bound to register the FIR if he has doubt about the veracity of the complaint. Principle laid down: the FIR is pertinent document that helps in setting the criminal law in motion and obtaining information about the alleged criminal activity. The scope of preliminary inquiry is not to verify the veracity or otherwise of information received, but only to ascertain whether information reveals any cognizable offence. The category of cases in which the preliminary inquiry may be made are as under matrimonial disputes, commercial offences, medical negligence cases, corruption cases. However, there is not any exhaustive list. Judgment: registration of FIR is mandatory under Section 154 of the Code if information discloses commission of cognizable offence and no preliminary inquiry is permissible in such situation. If the information received does not disclose a cognizable offence but indicates a necessity for an inquiry may be conducted only to ascertain whether a cognizable offence is disclosed or not. If the inquiry discloses the commission of a cognizable offence, the FIR must be registered. A preliminary inquiry should be time bound, and this is a point to be noted. Time bound in any case, it should not exceed 7 days, and reason for delay must be explained in journal diary. All the information related to commission of cognizable offence must be entered in journal diary. So this was the case. It was a very so to sum up, you can say that if the facts of the case are such that it in a very prima facie reveals that the case is of cognizable offence, then the preliminary inquiry is not needed. But where the facts doesn't reveal such, so that the offence is not a cognizable offence, and then the preliminary inquiry can be conducted, but it should be time bound. It should be conducted within 7 days, and the reason for the delay must be noted in the journal diary. So this was all. If you like this video, do click on the like button. Don't forget to press the bell icon, click on the subscription button. Thank you.